Hey guys, this is Scott Horne with Horne and Associates, and just want to take a moment and talk to y'all about proper documentation in a seller finance transaction. So if you find it helpful, take a minute and like it, please. Feel free to make any comments below. We'll do our best to get back to you. Flop over and join our YouTube channel as well. I think it's a great thing for you to look at and consider in that regard. So I just want to take this time and talk about just some basic little things, legal mistakes that can be made by the investor on an owner finance transaction. And it all starts with your contract. I like to use promulgated contracts if your state has them. I think most states have some form of a basic contract that can be used. And since you're not a realtor, I think you can use whatever you want to use to, for the most part. Here in Texas, we use the Texas Real Estate Commission contract form. Now, as an investor, I can use whatever I want, but I use that because it's there for a reason. It has all the things in there necessary that the state believes protects both the seller and buyer. So often I hear from so many investors that, well, sellers or buyers, they don't understand that. It's just too complicated. And of course, if you're talking to a seller about a contract, how in the world do you think they bought their house in the first place? It was with that exact same contract, maybe an older version. It's the same thing. So don't sell your seller too short, but I see that so often out there. When we're dealing with closings in real estate, it's so important to ensure that you are protected. In that contract, make sure you filled all the blanks in appropriately, closing dates, etc. Earnest money. Do things that bind your contract appropriately along the way. Next is have proper disclosures. You need to understand what the rules and regulations are with seller financing. They keep changing us a little bit. The Fed does things, maybe your state does it. Here in Texas, we probably have most of the rules and regulations, it seems like, over most other states, but you've got to know what your property code says in your state. You've got to know what the federal rules and regulations are. And just basically here in Texas, we have our Texas Property Code and Finance Code, that there are certain things that we have to do and provide between a seller and a buyer whenever there's going to be a lien left in place. Now, if you're not leaving a loan in place, fine, makes it a lot easier. But so often we investors have an existing mortgage on the property. Next is you need to understand these federal requirements. Now, what does the SAFE Act say? What does Dodd-Frank say? You don't need to be an expert on, but you need to have the generalities. And over on our YouTube channel, we have these laid out a little bit for you already. What is RESPA, the Real Estate Settlement Procedures Act, and how does that relate to us, whether we're buying or selling a house? Understanding the nuances is so important to get under your belt. And then it's making sure you provide the proper disclosures to your buyer. And what am I disclosing? Well, I'm disclosing what are the terms of the deal that I'm buying or that I'm selling. What's the contract price? Is there going to be a down payment? If so, how much? Is that down payment going to be paid all up front at one time or paid out in some format? What's the loan balance? What is the interest rate? Am I buying this home subject to the existing debt? Am I buying it with a wraparound mortgage? Am I selling it subject to or with a wraparound mortgage? What's the interest rate? What's the term? What's the monthly payment? What are estimated taxes, estimated insurance? Is there going to be a loan servicing or admin charge or fee? What are the closing costs? Keep in mind, guys, when we're doing a seller finance transaction, we are the seller. We are the lender. There isn't a mortgage company involved. There's no one to tell the buyer what the terms of the deal are. What are the closing costs? What can they expect? What are they going to get? What are their options? You've got to know what it is you need to disclose and make sure you're doing this. So many people just grab a contract off the internet or from this group or that group and go, we're done. It's going to be great. They never even read the contract. Guys, read the contract. Know what is in there and understand it. You know, if we're buying a home subject to, let's say, for example, I want my seller to understand what due on sale is and how that could affect them. I want them to make sure they understand that they're still liable on that debt until it's paid off. Not in 6 months or a year or 2 years, when it's paid off. I want them to understand things like they can't just interfere once I buy the home with me and the mortgage company, although some try to do that. I want them to understand that, they can get title insurance if they want it. They can use a loan servicer, several things that they can do along the way. I want them to understand what their options are, because so options these sellers will never even read the paperwork or do anything. They're just going to trust you to do the right thing. And if that's the case, guys, you better be making sure you're covering your rear end. We call that CYA, of course, because you'll need to, because sellers have short-term memories out there. We want to make sure we're handling all these little details. And if we're selling a home to a buyer, especially with a wraparound mortgage of some type, we want them to understand that there is that existing mortgage, how it's going to be handled, that they're going to be paying a loan servicer, which protects them from bad actors out there that do exist, unfortunately, and items of that nature along the way that can come up. Another thing that pops up out there with the investor world, especially when they're buying a home subject to, is they think that if they record their deed, it might create a problem with the mortgage company. Guys, there are requirements out there, like for instance here in Texas, you have to close with a title company or a law firm. And we are required to record these documents within 30 days of closing, and usually within a matter of a few days. So that's the first part. Trying to go out and doing a kitchen tabletop closing here in Texas, those days are over. Other states, maybe. But you should record your documents, because if you don't record your documents, that seller could sell the house to somebody else and you're screwed. Liens come out, they could affect that property on behalf of that seller, and you just bought all those liens. So never hold your documents back, record your paperwork, and things of that nature along the way. When you get good paperwork and you have good contracts, good disclosures, with a good understanding of what's going on, you wind up having a good transaction between the seller and the buyer, whether that's us as an investor buying a house or selling it. Either way it might be. If you need help with this kind of stuff, guys, we here at Horne & Associates PC are here to help you out in the Texas marketplace, as well as our sister company, OFN National Escrow, that helps investors close creative finance deals nationwide. So guys, I hope you found this video helpful. If you did, take a minute and like it, please. Don't forget to comment below. Jump over and join our YouTube channel. We'll see you guys next time.